Good evening, everybody. My topic to you this evening is entitled Anticipating and Defending Against Inevitable Courtroom Attacks on PA and Your Case. There's actually a third component of the title which was not added, but it's equally important. I think that it's important to anticipate inevitable courtroom attacks. I think it's important to defend against inevitable courtroom attacks on PA and your case. And then I also think it's important at all times to be prosecuting and moving your case forward. So this talk really will involve those three elements of anticipating common attacks, defending against them, and at all times prosecuting your case, moving your case forward, hopefully in a positive way to a good result. As I have mentioned and other speakers have mentioned many times before, I think the key to be able to accomplish these three goals that I've mentioned starts with preparation. Preparation both on the client, the targeted parent or grandparent's part, and also preparation on the lawyers and the professionals involved in the case. This is not something that you can show up in court on the day of final trial and at that time expect to handle an onslaught of attacks, geared towards PA and your case without having really thought about them, let alone knowing what you would do if they came up and arise during the course of the case. So the preparation starts months and months and months before trial, identifying what would the common attacks be. And if you don't know, I would encourage you to speak to those in the field that are experts, either consult with them or have them brought on as co-counsel to help you in these very important areas, because you can have the legs of your case sliced off or cut off, if you will, if you haven't given any thought or proper thought as to how you're going to anticipate and defend against these attacks. I look at a trial in many respects as a chess game where there's always a move and a counter move. And if you're good at it, and I'm really not good at chess, I think I'm good in the courtroom, but you should be able to think maybe a move or two or three ahead and think of your move, think of the opponent's counter attack or counter move, so that you're not simply reacting, you're also prosecuting, as I said earlier, your chess game, hopefully to checkmate if you can. The courtroom attacks that you will find on PA and on your case are really varied in many, and they can come at any time of the case. They can come in different colors, sizes, and shapes. But I think the more that, particularly the attorneys listening to this talk, the more that you practice and handle cases in this area, the more you will see common themes, similar attacks, which will raise their head over and over predictably. And it is inexcusable, certainly for an experienced PA lawyer, but even those that are not, to have not reached out and try to figure out, well, how are they going to attack this case, and to be well prepared once trial starts. I think that through working diligently, both with other experts in the case and other legal professionals who have tried these cases, you should be able to predict these type of attacks with much more frequency. You may not be able to anticipate every single one of them, but you certainly should be able to be prepared for the bulk of them, because they do come, and if you're not prepared, you really will be flat-footed and do a disservice to your client. Probably the foremost and most obvious attack that we see on PA and on your case involving PA is one that deals with the very counterintuitive nature of PA itself, and the opponent representing the alienating parent is almost certainly going to argue that the reason why the child or children are rejecting your client is because your client is really a bad parent, or engages in bad parenting techniques, or has engaged in questionable parenting techniques and behavior, and that essentially this is a case of estrangement. where the children don't want to see or have a relationship with the targeted parent because the targeted parent has pushed them away in words and deeds and omissions, etc. And I think that you have to be prepared for almost the entirety of the other side's case, trying to pin the blame for everything wrong with the relationship and the contact refusal on the targeted parent and his or her poor parenting. So that's something that you have to identify in advance. What are the deficiencies in parenting that you are willing to acknowledge? What are the maybe less than perfect actions and activities that the targeted parent has engaged in over the years when it comes to the children and parenting? I think it's healthy and appropriate to admit that there have been some mistakes, and sometimes the parent hasn't acted at his or her best. This by no means is conceding that the contact refusal or refusal to have a relationship is your fault, but I think it's important to take responsibility for those things that I think everybody in the courtroom is going to assume is something that you did and you did wrong, and know that the other side is going to be building their case as much as possible. So in that regard, I think it's important for the targeted parent or grandparent to tell his or her lawyer as much as possible of what those kind of hot spots or dangerous spots in the case will be. You know, the lawyer only knows the facts of the case as reported from the client and other sources as well. And if you're hiding or keeping back some bad parenting moments, that's going to somewhat hamstring your lawyer from being able to present the most efficient case and efficient response, anticipating what the attacks will be and how to counter the attack in a way that continues to prosecute the case. The whole case, really, with respect to that item that I've been talking about, the whole case needs to be tailored to show that the opposite is true, that this is not a case of estrangement. This is a case of parental alienation, which is caused by the unjustified and unwarranted behavior and undue influence of the alienating parent, which has caused the child or children to reject the alienated parent or grandparent. And that really starts with how you frame the themes of your case well before you get to trial. That starts with an opening statement that you give. I'll be talking about that a little bit later in this presentation. It certainly starts with the evidence, or continues with the evidence that you present, the witnesses that you select, and the testimony that you elicit that helps counter that argument that this is a case of estrangement and bad parenting on your client's behalf. And then obviously the use of expert witnesses, which I'll be talking about in more detail. And finally, it carries its way all the way through closing argument at the conclusion of the case, where you're summing up the evidence and you're giving your reasons and explanations as to why things have occurred. This effort to anticipate a full frontal assault on your client, on PA, on the case, and to be able to maintain that level of consistency and focus throughout the case, defending against that claim to show that it's the result of the alienating parents' actions, not estrangement or the actions of your client, is probably one of the largest themes that you'll deal with in these cases. Another common attack that we see over and over again in parental alienation cases is either a motion that's been filed or something that comes up in the middle of trial, if the court permits it, which is essentially the other side arguing that, let's say, Dr. Smith or Dr. Jones should not be able to testify in the case because he or she has never interviewed the children, and he or she has never interviewed the other parent, the alienating parent in this example. So as representing the targeted parent or grandparent, if you've hired an expert witness that's going to testify after doing a forensic review of records about the dynamics of the family, whether or not alienation exists, if it does exist, how serious it is, and how it needs to be treated, you can anticipate almost with 100% certainty that there's going to be an argument somewhere along the way that your client should not be permitted to call that witness because that witness did not meet with all parties and interview all parties. So there's a number of ways to counter that type of an attack on your case and on that aspect of PA. First of all, it's important to know the difference in your jurisdiction between a child custody evaluation and a forensic review of records. I would urge you to study the statutes and applicable rules that deal with child custody evaluations. Let me stop on that point for a second. There's no doubt that a child custody evaluation requires the evaluator, that's typically appointed by the court or agreed by all parties to perform an evaluation, to meet with and interview all parties, and sometimes in combination, mom with kids, dad with kids, etc., kids individually, dad individually, mom individually, in order to give a complete and thorough analysis of the family dynamics and opinions and recommendations. And to the extent that somebody who's performing a custody evaluation fails to meet with one or more of the parties, that certainly is a grounds for that person not to be able to testify because that person didn't do his or her job in accordance with the applicable statutes. However, a forensic review of records, which is what we typically have, or what is typically the case when we hire an expert witness to testify for us in a PA case on the side of the targeted parent, it is common. It occurs many, many times a day across the country where that person will review records, listen to tape recordings, view videotapes, review text messages, our family wizard communications, school reports, medical reports, psychological reports, depositions, statements of witnesses, etc., and then render an opinion. And it happens over and over again that there are attacks made that such a person cannot testify and should not testify because that person didn't meet either with the children and or with the the alienating parent. And that's just not so. And you need to be able to articulate the differences between a custody evaluation and a forensic review of documents and records. I would suggest that you pull some cases, maybe quite a few cases, in your particular jurisdiction. And I say you, I'm speaking to the lawyers, but if for some reason the lawyer is not doing this, the targeted parent, the client in my instance, certainly can encourage and remind the lawyer to look into this. To pull cases in other areas of law in your jurisdiction where this exact behavior or practice is permitted. So the best example, which you've probably heard if you follow our program, is that in the area of medical malpractice, where an expert witness is hired to review records and render an opinion as to whether or not there was negligence or gross negligence in a particular, let's say, surgery, and maybe even the patient in that case died. It's a wrongful death case. So clearly the forensic examiner cannot talk to the deceased and almost never, if not never, has an opportunity to speak to the defending doctor about what he did and what he didn't do. And the expert is permitted in all jurisdictions to give opinions based on reasonable medical certainty and probability as to what was the likely cause of this person's death. And that's done again by reviewing records, nurse notes, hospital charts, EKGs, and the like, without speaking to all the parties. Another area would be like accident reconstruction. Somebody comes to the scene and tries to reconstruct how an accident occurred and who's at fault and what were the rates of speed that the vehicles were traveling, et cetera. And it may be that one or more persons in that instance are deceased and cannot be spoken to. And typically the reconstruction expert that's hired on behalf of the plaintiff doesn't have an opportunity to talk to the defendant, whether it's the owner of a trucking company or whatever it may be, and is permitted to give opinions based on, again, reasonable certainty in that particular area. And the case law is filled with many, many other examples. And I would encourage you to just have 4 or 5 or 6 where courts in your jurisdiction have permitted these types of review of records and testimony without talking to all individuals involved in the process. And I think you'll be very well equipped to handle that particular attack. Speaking about experts for a moment, and about this issue that the attack comes that Dr. Smith, which is the targeted parent's expert witness, didn't speak with the children or with the person who's accused of being the alienating parent, but the expert witness has spoken with your client, the targeted parent or grandparent. I think this is an area that's a little bit gray and has to be addressed on the front end of an assignment with the expert as to what level of communication should occur. It should be cleared with the lawyer. There generally should not be an open line of communication between the client and the expert witness. Why? Because everything that the client sends or says to the expert witness is discoverable. And you wouldn't believe the things that clients would send and do send to expert witnesses if they're not admonished otherwise, that are horrific and they really hurt the case. And they should not be made discoverable by doing so. So that's something that has to be considered. Also, how much communication between the hired expert and the targeted parent is permitted. Certainly some background information is permitted, maybe some direction about where to go and what to look for. But I've seen some pretty effective arguments, even though an expert witness can testify based on a forensic review of records. I've seen some pretty effective arguments where there's hours and hours and hours of meetings between the expert witness and the targeted parent, where no matter how you spin it and what you try to say, it looks wrong, and it looks or can look wrong, favored, biased, a hired gun, just out to kind of put down in more professional jargon what it is the targeted parent wants to say. So that's probably beyond the scope of this discussion, but I do think that these are areas that need to be reviewed and looked at and attended to by the lawyer with his or her client. Another attack that you should clearly anticipate and expect in almost every PA case would be that words to the effect that PA is junk science, or there's no methodology behind PA. It's a weak area, one that's not well established. You'll hear these types of phrases and statements. I'm not going to speak in any detail about, excuse me, a Daubert challenge where someone is trying to throw out an expert witness's testimony based on improper methodology or that fact that it's not reliable or credible. I know that I believe tomorrow Dr. Burnett will be speaking about that very topic, and I don't want to steal his thunder or tread on his topic, but clearly one common attack on a PA case that you need to anticipate and defend against is that it's likely your expert witness is going to be challenged. Some courts require it to be pre-trial, some courts permit it during trial. And if you haven't given any thought to how to defend against the Daubert challenge, you are in grave risk of losing your expert witness. So again, beyond the scope of this discussion today to go into that in any great detail, but you must be prepared to protect and defend against any attacks on your expert witness for, again, not being reliable or credible or having proper methodology. You should pull in advance of those type hearings, and certainly have as part of your trial notebook for a trial, the exhaustive, there's plenty of material out there to show that PA is well validated, that involves well-validated principles of clinical reasoning and medical decision-making, that there are many articles and treatises and publications on methodology about how to rule in and rule out parental alienation. There is plenty of literature and learned treatises about PA being accepted by mental health professionals, certainly accepted by courts. And all of these things you need to think about very carefully before you get to the courtroom of what do I do if they attack my expert witness that he's or she is purveying junk science or has no valid methodology to support the testimony that's given. It would be a very, very heavy and serious mistake not to have given that thought before trial. I would do many things in this regard. I would cite to the various publications that have been mentioned in prior talks to mine that indicate, I think it was over a 15 or 18-year period, that there have been 1,181, and probably as we sit here today, well over 1,200 appellate opinions across the land, across the US, that have in one way recognized, addressed, or adopted parental alienation, or at least the elements of parental alienation. So when the other side gets up and screams and shouts, PA is junk science and the expert shouldn't be permitted to testify, you can both pull out those kind of articles that show that there's been over 1,000 cases in the US that says to the contrary. And then I would also urge you to do research in advance of your trial and research the prevalence of and existence of cases in your jurisdiction where PA by, I'm in Texas, maybe the cases in California, New York, wherever, where that particular jurisdiction has written about and published cases on the appellate level dealing with PA, its acceptance, its reliability, et cetera. And that will usually shut down that kind of an argument when you can show the court that there's 5, 6, 7, 10 cases or more in your jurisdiction that say exactly to the contrary. So you do not want to be surprised with these things in court without having anticipated them and addressed them and be prepared to defend them. And then again, I keep on saying, and to move to the next step, which is to prosecute your case. I kind of look at these attacks, I take them all seriously. I don't downplay any of them, but I feel like it's sort of running through a gauntlet where you're having some things thrown at you, or maybe a better example is you're riding a bicycle and there's some tacks in the road and you better avoid them or else your tire is going to pop. And I think these are easy to avoid and maneuver around if you're well prepared and you've anticipated and you're ready to defend against these kinds of claims. Be able to show, and this will be, I'm sure, dealt with in more detail in Dr. Burnett's talk about Daubert challenges, but be able to show that the testimony that's going to be offered by the expert is material and relevant, that it's probative and admissible, and that it meets all of the requirements as set out in Daubert and its progeny, that the opinions are have been peer reviewed, they're subject to replication by other experts, et cetera. I'm not going to go through all the different tests and elements, but I always carry to trial with me in whatever jurisdiction I'm in, the leading case that sets out the Daubert criteria. And I've already made notes next to them, if not paragraphs next to them, about how I'm going to respond when there's a challenge made. If it's not done pre-trial and I don't have advance notice, how would I respond in trial at a moment's notice when I call Dr. Smith to testify and the other side makes a motion that's accepted by the court to strike that expert based on Daubert criteria? Again, it would be too late to start thinking about that at that moment. And you will be panicked, if not worse, if you haven't prepared for that inevitability. Another area, and I know I'm jumping through a lot of them, and there's not any particular order of importance, but these are the ones that came to me as I was thinking about this presentation. And there's even more that I'll be able to address in the course of this topic. But another attack that we hear on PA and on the targeted parents case is that, well, you know, if you look in the DSM-5, the diagnostic and statistic manual that's used by mental health professionals and others, you're not going to find any kind of listing of parental alienation. So if it's not in the DSM-5, it certainly can't be anything valid or worthy of consideration by this court and should not be heard. While the words parental alienation are not used in the DSM-5, there are many circumstances and factors that are listed in various sections of the DSM-5 that essentially address exactly the elements of what PA is. There's a section about child or children affected by parental relationship distress. There's material about parent-child relational problems. And I'm not going to have time to go through each of those with you here today. Other speakers, notably Dr. Miller, have spoken about this before. But you should be able to pull out quite easily from the DSM-5 material that will support PA both being recognized, being addressed, and what the proper treatment is for it. The other thing, by the way, is I think all of us know from these cases and participating in this program that PA is basically child abuse. You will find language in the DSM-5 dealing with child abuse, as you will in other publications that are recognized across the country, to show that PA is a very serious form of child abuse. And you're basically making analogy and using the very terms terrorizing, corrupting, these are in other publications, the child. But again, the words parental alienation are not used, but you can make those analogies very effectively if you've already pulled them, studied them, and anticipated the attacks on this particular basis. Let me move on to another attack on PA in your case that you need to anticipate and be ready and able to defend, and that is that, well, PA is not a syndrome. This is parental alienation syndrome doesn't exist. We hear that with quite a bit of frequency. I think that this whole concept of PA is not a syndrome, and parental alienation syndrome doesn't exist is really one of the favorite children, if you will, or favorite arguments of the anti-PA group, of which there's many, to try to attack PA and show that it should not be recognized and adhered to by the courts. I'll read you a definition from the DSM-5 about what a syndrome is. A syndrome is a grouping of signs and symptoms based on their frequent co-occurrence that may suggest a common underlying pathogenesis, course, familiar pattern, or treatment selection. Now, if you stop there for a second and you just talk about the 8 manifestations, and of course there's even more than 8, but 8 manifestations that alienated children typically demonstrate and show, there's no question that those are a grouping of signs and symptoms based on their frequent co-occurrence that may suggest a common underlying pathogenesis, course, familiar pattern, or treatment selection. So if you get locked into an argument in court with a judge that's really determined to make you show that it's a syndrome, you can use the DSM definition very effectively with the 8 manifestations and show that it is in fact a syndrome. But sometimes you can avoid stepping into this problem by just not calling it a syndrome. I would probably encourage you not to do that. Once you do, that will trigger this likely counterattack by the other side. But even if you do, you should be prepared to define and defend, excuse me, that this is in fact a syndrome, but it's not necessary that it be called a syndrome or labeled a syndrome or deemed to be a syndrome for any of the validity and methodology that's set out by the voluminous literature that should somehow be invalidated because of the use or non-use of the word syndrome. Many authors with anti-PA bents distort the definition of syndrome, take out the word may in the definition that I gave you above, and other perversions and permutations of this. And you just get tangled in a web if you haven't thought this through and be able to carefully articulate to the court the issues that pertain to this attack, which is common, that parental alienation syndrome doesn't exist. Another area or an attack I think that you need to be familiar with is the difference between a expert or a clinical witness and a fact witness. This first place to start would be the rules of evidence, the rules of procedure in your particular jurisdiction, which have many rules and requirements beyond the scope of this discussion as to how experts are governed and how fact witnesses are governed. Fact witnesses generally can relay and relate factual data and statements about what they observed or what happened, chronologies, etc. But fact witnesses are not permitted to give what falls under typically an expert witness opinion purview and give prognoses or sort of estimates of what's going to happen in the future. Expert witnesses can't. For example, you've heard in the course of these presentations, you've heard about adverse childhood experiences, or ACE experiences as they're referred to, where children who have suffered and are suffering from alienation run a much higher risk than the general population of pretty much everything bad you can think of: suicidal tendencies, drug use, juvenile delinquency, and on and on. An expert witness should be able to give, if you understand the rules properly and are prepared for an attack that says the expert can't testify on this topic, experts should be able to give opinions, projections, and probabilities under the rules of your jurisdiction and the case law that supports it. It's done all the time. But you're going to hear objections from time to time that your expert can't do it, can't make projections, can't offer opinions regarding probabilities based on the forensic review of documents. And it's just not true. It's just not so. And you need to be prepared to show the judge why that's the case. Experts can give, as I said, opinions and projections and probabilities based on reasonable medical or psychological or clinical certainty. And most of that is embedded in the rules themselves, but also in the case law. And I like to have both. In my toolkit that I bring to court for trials, I'll have my local rules and I'll have some cases that I've already researched and pulled, because I've already thought about where are the hotspots going to be with the expert witness and what are the challenges going to be above and beyond any Daubert challenges. And then I've got the rules and the cases with me to show the court, and it's almost seamless when the other side gets up and objects. And I say, well, Your Honor, let me show you the case of ABC and rule number, what have you. It's usually very effective, and it looks like you're totally in command of what you're doing, and you're leading and prosecuting your case through those kinds of efforts. I think that you should also, switching to another common attack on PA and your case that you should anticipate and be able to defend against, is objections that are made during the course of trial. One would be that the witness is speaking in a narrative. Now, there actually is not in the rules of evidence that I'm aware of a rule that says a witness cannot speak in a narrative. It's much more problematic for a fact witness to speak in a narrative than it is for an expert witness. I think what's really at the heart of the objection narrative is what you would hear, which obviously is an attack on your case, because if the judge sustains it, that means the witness doesn't get to testify on that point, or at least that question. I think what's really at issue is non-responsiveness. So people confuse the two all the time and say objection narrative, when really I think the objection is geared towards the person as being non-responsive. So on April 18th, I gave a talk for this organization about how to prepare targeted parents and grandparents for courtroom testimony. And I spent a fair amount of time talking about a lot of basic rules that I think would be helpful to avoid these kinds of problems, so you don't fall into the trap of being non-responsive in your testimony or something that could be characterized as a narrative. An expert witness should be able to give a narrative answer as long as it's responsive to the question that's asked. A fact witness needs to identify whether the question is a direct question, which should be answered yes, no, I don't know, I don't remember, but basically with a short, direct answer, or if it's an open-ended question, which is why, how come, please explain, give me your reasons, what's your support for? And in that instance, that's where a fact witness might typically be guilty of a narrative response. And if you've practiced and you've thought about your answers and you give what I referred to in my talk as a Roman numeral outline answer, where you give the main points of, well, my reasons are 1, 2, there's also 3, and perhaps 4, that's going to be a good tight answer that should survive an objection on narrative answers. So how this is anticipated and defended against best is by working hard and preparing with your lawyer, or the lawyers working hard and preparing the clients to anticipate areas where there's voluminous amounts of material to be covered, and how it's going to be broken down by question and answer. And when it is answer, how it's going to be succinct, tight, responsive, etc., so that the material can get into evidence. I think that's something you need to be able to anticipate and defend against. They're switching to another attack that we see, one that should be anticipated and is easy to defend against if you do anticipate, is that learned treatises, books, publications, periodicals are hearsay. So let me digress for just a second. Hearsay is basically an out-of-court statement that is being offered in the courtroom to prove the truth of the matter asserted. So an example would be, Steve is on the witness stand and says, I heard Joe say that he saw Bill shoot the victim. The problem with, and that's being offered for the truth of the matter asserted, meaning Bill's the one that actually shot the victim. And we're trying to get through it by what some other person out of court said. The general philosophy behind hearsay, the lawyers know this, the witnesses need to have a general understanding, or the clients need to have a general understanding, is that hearsay is problematic because if we just permitted everybody to get on the witness stand and say, I heard Bill say, I heard Jim say, I heard Susie say, it would be endless. And there'd be no way oftentimes to counter those kinds of statements without support. So the interesting thing, though, is in most jurisdictions, as far as I know, there are a list of 24, 26, I can't recall, hearsay exceptions. So in the rules of evidence in your particular jurisdiction, there are exceptions to hearsay, which if you fall into the exception and you meet the criteria, the court should admit the evidence as an exception to the general hearsay rule. So learned treatises, publications, articles, what have you, they're out of court statements, and they are perhaps being offered to prove the truth of what's stated in those articles. And when you do so, in other words, offer them, the other side says, objection, hearsay. So the first response is, Rule 803 of the Rules of Evidence in most, if not all, jurisdictions has an exception number 18. And that exception says statements in learned treatises, periodicals, or pamphlets would be admissible if two things. One, the statement must first be called to the witness's attention, which of course that's going to be done during the examination. And two, the publication is established as a reliable authority by the expert testimony, him or herself, or by another expert's testimony, giving credence to the reliability of that publication, or through what's called judicial notice. There are some publications, that are so well known that you can ask the court to take judicial notice, and the court will do so, and that's the equivalent of having the statement admitted. You got to think through these things before you get to trial and anticipate that all of them will be attacked, and be prepared. You will be, again, so much more professional, so much more polished, so much more seamless in your presentation had you thought this through and not stumbled when the other side says objection, hearsay. I think that I'm going to go down this path a little bit longer than I anticipated when I first started working on this talk, but I think there's some other hearsay objections and exceptions to the hearsay rule that should be anticipated to help get statements into evidence in trial. What am I talking about? I'm talking about generally statements of little Johnny said, or teacher so-and-so said. Generally, those kinds of statements are problematic to get into evidence because they're hearsay. Otherwise, we could all say, little Johnny said this, and the other one says, little Johnny said that. And there's no way of really knowing because we're not going to put little Johnny on the stand, hopefully, in most cases. But there's about 5 or 6 or 7 quick little hearsay exception rules, in addition to the learned treatise one that I just gave to you, that I think will be helpful to you in anticipating attacks on child statements or other witnesses' statements, and getting those statements into evidence, which allows you to continue to prosecute your case and move your case along efficiently and convincingly. The first exception to the hearsay rule is called a present sense impression. And a present sense impression is a statement which describes an event or conduct which is made while or immediately after the declarant, the person that's making the statement, perceives it. So again, it's a statement that describes an event or condition made while or immediately after the declarant perceived it. That may be one way to get in little Johnny's statement, by arguing that it's a present sense impression. Number 2, hearsay exception, similar to number 1, but slightly different. It's called an excited utterance. A statement that is about a startling event or condition made while the declarant, the person that's saying it, is under the stress of the excitement that caused it, can also be used as a hearsay exception. So again, an excited utterance, someone makes a statement, a child makes a statement in a startling manner while he or she is under the influence of the event, may very well be able to come in to evidence as a hearsay exception. Another statement that I think is relevant to this area that we're talking about, PA cases, because we're usually dealing with mental health professionals and records and the like, medical records, school records, would be a statement of the declarant's then existing state of mind. It could be to show motive or intent or plan or some sort of emotion or sensory experience or some sort of physical condition. Again, the buzzword here is state of mind. Often you can argue in response to someone that argues hearsay, you say, well, Judge, I'm offering it for state of mind, not for the truth of the matter asserted, but to show what the person's motive was or intent, etc. Fourth hearsay exception that I think is relevant here is that certain statements which are made for medical diagnosis or treatment fall into the exception to hearsay. And we have these all the time in our PA cases where there are statements made by someone in a medical record or in a therapy notes and the other side objects that they're confidential or privileged or hearsay or whatever, and you say 8034, Your Honor. These are statements made for medical diagnosis or treatment, and I often get statements in that way. I won't go through all the elements right now, but 8036, which is the sixth exception to hearsay, is called the business record exception, excuse me. And there's 4 or 5 characteristics or qualities that need to be satisfied, but basically records that are kept in the ordinary course of business that are made by a person with knowledge contemporaneous to the event, and it's the regular course and practice of the business to keep these records. That's one way to get in a statement dealing with a statement in a record that otherwise would be hearsay. Hearsay exception number 21 deals with a person's reputation concerning character, probably beyond the scope of my talk and the time that I have, but that's another area to get in and be aware of getting in statements if it's something that deals with reputation involving character. 24 is called a statement against interest, where someone makes a statement that would be so out of the ordinary against the person's interest that it has more credibility, if you will, because of that fact. And there are certain circumstances when that can come into evidence. Last quick evidence rule is an admission by a party opponent. So if you're representing the targeted parent and you want to get into evidence what the alienating parent said on a particular situation, that generally should be admissible. It's not even hearsay. It's what's called an admission by a party opponent. Where people get messed up a lot of times is they try to get their own clients out of court statements into evidence. And then when the other side objects, they say, well, Judge, it's an admission by a party, but that's not the full rule. The rule permits an admission by a party opponent, meaning the other side, not your client. So, and you can catch the other side frequently if you want to keep evidence out, where they're trying to test their own client's alleged testimony into evidence outside of the courtroom, or statements outside of the courtroom, and you object because the admission by party opponent rule does not apply, because that person is not an opponent. That person's trying to propound or advocate the admission of his own sentence. Let me, in about the 10 minutes or so that I've got left, let me talk about kind of a whole host of other attacks on PA and your case that should be anticipated and defended against vigorously. I won't be able to go through really any of it today, but you need to be aware of, there is just a whole host of anti-PA literature out there. One of them is referred to as the reformulation paper, which Dr. Miller has spoken about at length in other discussions, and I'm not going to go into the details of that, but number one, you need to know what literature and, in quotation marks, learned treatises and publications are out there that, if offered or referenced and you have no counter to it, you could be in deep trouble and may actually lose your case if the judge thinks that that's the prevailing view outside the courtroom on PA. You need to be able to, number one, identify the articles that are most hurtful. That can be done through discovery, that can be done through depositions, that can be done through examination of experts, but it also should be anticipated, even if you don't have any of those clues before trial. And you should be able to demonstrate to the court why the articles are either flawed or they're not credible or they're not valid, and have those arguments charted out like little cheat sheets, if you will, in your notebook. So when that comes up, you've got your arguments right there and you've already thought it through, and you're just, again, professional, seamless, carrying on the arguments and able to prosecute your case, to get over that hurdle and get back to prosecuting your case. An argument you'll hear, which is geared towards hurting your case and your efforts to prevail on a PA claim, is an argument by the other side, and sometimes it's by the court, which is, I don't really think you need much time, Mr. Hoffman, to try this case. We're going to give you a day or a day and a half or 4 hours or maybe 2 days. it's very important that you don't be, again, caught flat-footed and just simply say, well, Judge, I need more time. You need to be able to articulate, and I would have some thoughts charted out if you haven't done it before, as to why more time is needed. Why, for example, there may be the need for 2 expert witnesses, what each of them will do and how long it would take for their testimony to be developed, and then include cross-examination by 1 or 2 or 3 other parties, depending how many there are in the case. And that each, both the alienating parent, grandparent, alienating, targeted parent or grandparent could easily be on the stand a day or more between direct and cross-examination. There may be collateral witnesses, several on each side, that need to be examined. There may be very important mental health professionals and others that will be offered and need to be examined. It's almost unheard of that you can try a sophisticated, contested, severe parental alienation case in less than 6-7 days. And to the extent you can get 8, 9, 10, you're in much better shape. These are not quick cases. Sometimes they go on for weeks if the court permits it. Be prepared to argue forcefully for the amount of time that you need. And judges will generally give it to you if you can articulate your reasons. If you simply say, I need more time, that's likely not going to get you there. I think that I've said this several times throughout the course of the presentation about the need for expert witnesses. I think you'll hear quite a bit more about that throughout this conference over the next couple of days. But a way to defend, a very effective way to defend against the attack on PA in your case, is by having expert testimony. This is an area that requires expert testimony. Now, I recognize there are times and instances where clients simply can't afford it or need to conserve, efforts and resources. The client, him or herself, will not be able to carry the day on providing the factual basis for alienation and then somehow shift and offer opinions, because the court's not going to permit a lay witness, a fact witness, a client, to talk about PA as in any kind of expert capacity. So one of your best tools to defend against most of the attacks that I've said is by having good, credible, experienced expert witnesses, 1 or 2 in the case, who have been down this road before, who have been subject to Daubert challenges, who know where the hot spots are, who know and can spot when they're being led into a ditch, and they can step around it through careful answers and knowing exactly where things are headed. And also to have the expert witness educate the lawyer, even experienced lawyers like myself in this area. I always learn each and every case from good, experienced expert witnesses. And for the lawyers that are less experienced or don't have any experience in PA, I would really encourage you to associate a more experienced lawyer with respect to PA, and definitely get expert witness advice and testimony to bolster and support your case, because without it, it's very, very difficult to defend against the many attacks that I've talked about in the course of this speech. Another area, another attack, if you will, that comes in various shapes and forms, but it deals with the common theme of listen to the child. Either listen to the child or listen to the voice of the child, either because the child is 15 or 16 or 17 and the argument goes, well, he or she's almost 18 and will be an adult, so what's all the fuss about? Or it could be that the child is old enough to have a voice in these matters. We hear those kinds of arguments maybe for 11, 12, 13-year-olds. Or we hear that the child's old enough to make his or her own decisions, or the child is too old to be told what to do, or, if we tell this child what to do, this child's going to run away, and we're all going to have a mess on our hands. And I think for those of us that practice in this area and really understand and believe and know that PA is child abuse, we don't listen to, and we're not guided by as the single guiding decision, if you will, what children say. Children who are moderately to severely alienated have been brainwashed in one form or another. They have been persuaded through undue influence and other methods by their parent, by the alienating parent, to reject the other parent. They are the last voice we should listen to as to what's best for them. We need to rescue them and pull them out of the abusive situation that they're in. And you're going to hear these arguments all the time. I'm only giving you a couple thoughts on this matter because of my time limits, but I urge you to be well prepared as to how you're going to respond to the argument that the children have a voice and we need to listen to that voice and nothing else matters. Something I'm starting to see a little bit more is an attack that says, well, you know, these PA experts, they always find PA. So what's the point in listening to them, because they conclude that every time. Now, again, beyond the scope of this discussion, you need to have those kinds of discussions with your expert witnesses to see if they've ever had a case where they've ruled out PA. And if they never have ruled out PA, why that's been. And being able to offer nonetheless, even if this is one in a series of cases where they conclude PA exists, that they went through basically the scientific method to rule in and rule out all possible causes of the rejection and lack of relationship, including PA, and that all signs point to PA. But again, be prepared that you may hear this argument that your witness always concludes that there's PA, and I think you should have a well thought out response to that. Another area, briefly, and this may go to the experts, the mental health professionals, is be careful if you're doing a forensic review of documents that you don't list in your report things that would be basically a custody recommendation. And because of all these reasons, I believe that little Johnny should live with his mother, or make diagnoses of people that you have not personally met with and you know, did a full evaluation. These will get you in hot water, and they may actually get you struck from testifying. So be careful about that. And as a lawyer, I like to at least scan a report to make sure that that kind of material is not in there. Couple other quick points, and I will stop. One is that you should be able to tell the court, as the targeted parent or grandparent, factual scenarios and events with your own personal knowledge. It's a good objection that the other side will make, which is lack of foundation or lack of personal knowledge. For instance, the 17 alienating strategies, you're going to get asked, well, have you ever seen my client engage in any of these strategies personally with your own eyes, or heard it with your own ears? And oftentimes the targeted parent says, no. You got to think through that well before trial to be able to respond to ways that you're going to prove these things that you might not have seen occurring in your face. You might need other witnesses. It may be through documents, it may be through social media posting, etc. I would urge you to review an article by Richard Rorschach, 2015, in the APA journal. And the article is entitled 10 Parental Alienation Fallacies That Compromise Court Decisions and Therapy. I am basically out of time and cannot go through those, but every practicing trial lawyer and every targeted parent or grandparent that's going to be in a court proceeding needs to look at these common fallacies, because they're more along the lines of additional attacks. Some of them mirror what I've said already, but even additional attacks that are made on PA in your case, which you need to be prepared for with answers before the trial starts. It looks like I have utilized my time. Again, it's been a pleasure